Hey everyone, Harry here to talk about the scheduling in the January 6th case in Judge Tanya Chutkan's courtroom. Now, we talked yesterday about the actual hearing. Just to recap the main points. Trump wanted to have the longest schedule possible. His lawyer, John Laurel, argued, hey, we have a superseding indictment. It is a whole new case. And we want a motion to dismiss and another motion to dismiss. And we want to go first, which you normally would do if you're making a motion to dismiss. The government said, no, we're trying to comply with what the Supreme Court has told us. They kept it for 9 months, did their immunity ruling, and sent it back down to you, Judge Chutkan. That's where we really want to focus now. Okay, so the scheduling order that came out basically took the government's side in that, as Chutkan actually said in the hearing, immunity is the linchpin here. So the most important part of the briefing order gave the United States the first brief to argue about immunity. And among other things, they have a burden that they have to bear to persuade her that evidence involving Mike Pence, as we talked about yesterday, isn't immune under the Supreme Court doctrine, which good luck applying it for Judge Chutkan. It's vague in and of itself, and there's no burden of proof offered. But the doctrine is that the conversations with Pence are presumptively immune, can't even have them present as evidence in court unless the DOJ can show that they don't impinge on the function and authority of the executive branch, meaning basically that this is something, the executive needs to be able to do and have confidence other people won't talk. And just another quick point about the Pence stuff. The Supreme Court dropped a little hint giving an argument to the DOJ, which is, hey, Pence here on January 6th is acting as a president of the Senate. You've got a dual role in the Constitution, the vice president does. And so maybe there's not browbeating him as Trump does. Maybe that's not impinging on the authority and function of the executive branch. But man, oh man, good luck with that. And, Trump made it clear that's going to be the real focus here, because the conversations in question where Trump is really just slapping him all around, insulting him and the like, those are off the Oval Office, and it really feels like it's the president talking to the vice president. Anyway, that is the game that is now set up. Trump, for his part, wanted to say, we're going to move to dismiss the entire case because the grand jury heard evidence, the new grand jury that returned the superseding indictment, heard evidence from Pence of those conversations. That taints the whole thing. We've got to start all over again. All right. And they also wanted to do all these different motions. The DOJ said, look, we can do them at the same time. But we really want to focus on immunity. And this is probably the most important sort of practical point. Everyone knows this is likely to go up again. It's immunity, and immunity gives a right to an immediate appeal because the right in question is not to stand trial in the first place. So it was common ground. Chutkan, frustratingly said, we know this is going to go up again. DOJ as well, but the goal is it go up only one more time, and that to do that, you need to take care of all the immunity issues. Okay, so that set it up, and now Chutkan's order says first, we're going to focus on immunity, and the DOJ does go first, as the DOJ wanted. It's not the motion to dismiss that Trump is making, but the DOJ's effort to apply the Supreme Court case, especially overcome the presumption with Mike Pence. They'll go first. Their brief is due September 26th, and then the Trump answers October 17th. DOJ replies October 29th. In other words, ain't nothing going to happen in this case before the election. It would be very fast for starters, and just not something I think that would be in Judge Chutkan's character to rush something out on, a day or two after October 29th. So we're not going to see any mini trial, any evidence about anything in the case having to do with immunity. There's a asterisk here I'll drop in a moment, before the election. So all the hope for the trial in the first instance, and then for the, an evidentiary mini trial, anything like that, I don't see. It's not going to happen before the election. And on the evidentiary mini trial at all, there was a little kind of cryptic suggestion from Chutkan that maybe she would need to hear evidence from Mike Pence that would come after to decide on whether the presumption is overturned. But I think the best reading is she was just saying she needs argument, and it's not enough to just go on the indictment as it stands. Okay, so that's the main event. Is they're going to go through everything in immunity. They're going to make their arguments and serve it up to the judge as of just a few days before the election. She added that no sense setting a trial date. Everybody knows this is going up again, so she stayed all the deadlines that are already out there. The other thing that she did was for all the remaining loose ends, and they are many. Remember, the Supreme Court just parachuted in and stopped it last December. She did set dates for briefing and the like, but those largely dovetail or coincide with what's happening in immunity. So the parties will have to kind of work. There's a lot of lawyers on both sides. Shouldn't be too hard, but we'll have to work double time to do those papers as well, at least to submit them. And she may, and she's a really diligent judge, may sort of work through them as the other briefing is coming in. But the focus is going to be on immunity. More particularly, it's going to be on Mike Pence. More particularly, it's going to be on whether or not the presumption of immunity that the dealings with the vice president would enjoy is overcome. But that's all going to happen at least after November. So, once upon a time, this looked like a case that might go to trial quickly and was in many ways the most important case because it gets to the core. Even though the Mar-a-Lago case is cleaner case, this really gets to the core of his constitutional wickedness. But the Supreme Court foiled that when they came in, and now that Chutkan has to deal with the mess, to be fair and candid. At one point, the Trump lawyer said the guidance is clear, and there was peals of laughter in the courtroom. She's going to have to deal with that and hope it only goes up and down once. Hope she doesn't get reversed. Nothing's happening anytime soon, and definitely nothing of substance before the election. There will be evidence produced. It was the other part of the order that DOJ has to complete its discovery obligations. They say there's little or nothing left, but it could be that some of the evidence turned over to the defense, if the defense leaks it, will have a little sort of pack a little punch in the political landscape with Trump running for president. But that's what, the drama of the vice president in particular on the stand reciting the incredible, nasty, brutal treatment by Trump, that's not happening, and it may not, in fact, happen ever. It'll depend on what she rules about immunity. So there you have it. Immunity goes with the government, but nothing we're going to see or that I think will have a bigger impact in the political sphere before the election. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.